You just got called into your manager's office. The door closes behind you, and in the next 5 minutes, your entire world changes. You're fired. Maybe it was a layoff. Maybe it was termination. Maybe it came completely out of nowhere. And as you walk out of that building for the last time, carrying your belongings in a box, you have no idea that your former employer still owes you money, potentially thousands of dollars, and they are counting on you being too shocked, too overwhelmed, too uninformed to ever collect it. Right now in America, hundreds of thousands of workers are laid off or terminated every single month, and the majority of them leave money on the table simply because nobody told them what the law requires. Stay with me for the next 5 minutes, because after this video, you will know exactly what your employer owes you and exactly how to get every single dollar. Welcome to U.S. Legal Simplified, where we break down complex American laws into plain language that anyone can understand. Today, we're covering 5 things your employer is legally required to pay you after termination, whether they tell you about them or not. Let's get into it. Number 1, your employer must pay you every dollar of unpaid wages immediately. This sounds obvious, but it is one of the most commonly violated rights in American employment law. The moment you are terminated or laid off, your employer is legally required to pay you all outstanding wages. This includes every hour you worked in the current pay period, even if payday has not arrived yet, any overtime you're owed at 1.5 times your regular rate, and any commissions or bonuses you have already earned, even if they have not been formally paid out. Under the Fair Labor Standards Act, withholding earned wages from a terminated employee is a federal violation. Most states require final wages to be paid immediately on the last day of employment or within 72 hours of termination, depending on your state. If your employer delays your final paycheck or pays you less than you're owed, you can file a free wage claim with the Department of Labor at dol.gov or contact your state's labor board directly. Both options are completely free. Number 2, your employer must pay out your accrued vacation time. Most Americans don't know this, but in many states, vacation time you have earned but not used is considered wages under the law, not a benefit, not a privilege, wages. This means when you are fired or laid off, your employer may be legally required to pay out your unused vacation balance in cash. California, Colorado, Illinois, and several other states have especially strong protections here, where accrued vacation payout upon termination is mandatory, regardless of company policy. Even in states with weaker protections, if your employee handbook or contract promises vacation payout, your employer is legally bound to honor it. Check your employee handbook immediately after termination. If unused vacation payout is mentioned and your employer refuses to pay, that refusal may be a breach of contract you can pursue legally. Number 3, your employer must give you access to COBRA health insurance continuation. Losing your job means losing your health insurance, and for millions of Americans, this is the most terrifying part of termination. But here is what most people do not know. Under federal law, specifically the Consolidated Omnibus Budget Reconciliation Act, known as COBRA, if you worked for a company with 20 or more employees, you have the legal right to continue your exact same health insurance coverage for up to 18 months after termination. Your employer is legally required to send you a COBRA election notice within 14 days of your termination. If they fail to send this notice, that is a federal violation with penalties of up to $110 per day. Yes, per day. Now, COBRA coverage can be expensive because you pay the full premium yourself. But here is the critical thing most people miss. You have 60 days from the date of your termination to elect COBRA, and COBRA coverage is retroactive. This means if you get sick during those 60 days before electing COBRA, you can elect COBRA after the fact, and your medical bills will still be covered. This is one of the most powerful and least known protections in American employment law. Number 4, your employer must allow you to file for unemployment benefits. This one might sound obvious, but millions of Americans do not file for unemployment after termination because they believe they do not qualify, or because their employer told them they do not qualify. Here is the truth. If you were laid off or fired for reasons other than serious misconduct, you are almost certainly eligible for unemployment benefits under federal and state law. And here's something even more important. Your employer cannot legally prevent you from filing for unemployment. They cannot threaten you. They cannot retaliate against you for filing. And if they contest your claim dishonestly, that itself may be grounds for a legal complaint. Unemployment benefits typically replace 40 to 50% of your previous wages for up to 26 weeks in most states. File your claim immediately after termination. Do not wait, because benefits are calculated from the date you file, not the date you were terminated. File online at your state's unemployment insurance website, or search your state name plus unemployment insurance to find the correct portal. Number 5, your employer must honor the terms of your severance agreement. Not every terminated employee receives severance pay, but if your employer offered you a severance package, or if your employment contract includes severance provisions, that agreement is a legally binding contract. Your employer cannot offer severance and then reduce it. They cannot add conditions that were not in the original agreement, and they cannot delay payment beyond what the agreement specifies. But here is what most people do not know about severance. When your employer hands you a severance agreement to sign, you do not have to sign it immediately. Under the Older Workers Benefit Protection Act, if you are 40 years of age or older, you have a minimum of 21 days to review any severance agreement and 7 days to revoke it after signing. Even if you are under 40, you have the right to take reasonable time to review the agreement and the right to have an attorney review it before you sign. Many severance agreements contain clauses waiving your right to sue the company or waiving your right to file EEOC discrimination complaints. Never sign a severance agreement without understanding exactly what rights you are giving up. Many employment attorneys offer free consultations, and some will review severance agreements at no upfront cost. The money in that agreement may be worth far less than the rights you are signing away. So let's recap the 5 things your employer is legally required to pay or provide after termination. 1. All unpaid wages, including overtime and earned commissions, owed immediately. 2. Accrued vacation time, which is legally considered wages in many states. 3. COBRA health insurance continuation notice within 14 days of termination. 4. Your legal right to file for unemployment benefits, which they cannot prevent or retaliate against. And 5. Full honoring of any severance agreement offered, which is a legally binding contract. If your employer has violated any of these rights, you can file complaints with the Department of Labor at dol.gov for wage violations, your state unemployment insurance office for benefit denials, and the Equal Employment Opportunity Commission at eeoc.gov for retaliation, all completely free. You worked for that money. You earned every dollar, and the law says it belongs to you. If this video helped you, please hit the like button. It helps more Americans find this information when they need it most. Subscribe to U.S. Legal Simplified, because every week we break down the laws that protect you. And comment below, were you ever fired or laid off and not paid everything you were owed? I want to hear your story. I will see you in the next video.